was not their original statements 1 year prior. And there were witnesses who suddenly, we couldn't contact anymore, who went missing. This was a real issue in this case. And Mr. Moore was just a prime example of that. Another example was David Alegbe, who similarly had said that he had seen the passengers in his Uber speaking on a cell phone. That wasn't convenient for the prosecution's case because the brothers testified that they didn't have their cell phones with them. And there were two witnesses actually who had said this. There was an independent taxi driver who said one of the brothers was texting during the drive, and separately David Alegbe, who said one of the brothers was on the phone. Now, of course, after we had set that in our papers, OSP talked to David Alegbe and got him to write a statement saying he may have been mistaken about the phone use because it was inconsistent with their theory of the case. And Your Honor saw David Alegbe got on the stand and he explained not only did he hear one of them speaking on the phone for 1 or 2 minutes before the second brother got in the car at their house, which they tried to say he could have been rehearsing his acting lines for that evening, as if the profanities that was yelled at Jussie in the street would have been something that would have to be rehearsed out loud in an Uber. But separate from that, Mr. Alegbe said that halfway through the drive, they changed the destination in the app, which could only be done with the use of a cell phone. And that was not contained in the statement. That was never any of the OSP's disclosures to us. That was something we learned for the first time actually at this trial when Mr. Alegbe testified. In short, we think there were significant issues with the way the OSP treated this case with the defense witnesses, and they tried to have defense witnesses either take back their statements and give incriminating statements towards Mr. Smollett, which were not their original independent stories, or I suppose some of these witnesses, for inexplicable reasons, were just not available, for the defense to reach. So we think certainly a new trial is warranted based on all of these errors, but particularly on Mr. Moore and his statement at trial that he was threatened and pressured by the OSP to change his truthful testimony, which was exculpatory for Mr. Smollett. Next, I'd like to address the burden shifting. The OSP improperly shifted their burden to the defense on 3 different occasions during the trial. As the court well knows, it's entirely the prosecution's burden of proof, and it's reversible error to try to shift this burden to the defense at any point during the trial. And this happened first during the questioning of Detective Thies, then during the questioning of Abimbola Asundario, and again in the state's rebuttal argument, which was the final word the jury heard from any lawyer prior to retiring to deliberations. The seminal case on a prosecutor's improper comments on a defendant's post-arrest silence is Doyle v. Ohio, and that's 426 U.S. 610, 1976 case, which holds that it is a deprivation of due process to allow an arrested person's silence after that person has been Mirandized and advised of his Fifth Amendment right to remain silent, to then use that silence against them at trial to create an inference of guilt. And that's exactly what the OSP did here on 3 separate occasions. Now, in its opposition papers, the OSP tries to argue that their questions to Detective Thies and to Abimbola Asundario relate to a text message sent on February 14, 2019, and do not involve Mr. Smollett's post-arrest silence. However, the improper questions were not limited to the text message or even to the time period prior to Mr. Smollett's arrest. For example, in questioning Detective Thies, Mr. Mendenhall broadly asked, quote, did he, meaning Mr. Smollett, ever make a statement that they, referring to the Asundario brothers, did nothing wrong and never would? Answer, no. Question, to this day, has he ever come clean about this hate crime that you are aware of? Answer, no. This questioning indisputably violates Doyle, as it necessarily includes Mr. Smollett's post-arrest silence. Furthermore, Illinois law actually goes a step further by holding that it's impermissible to impeach a defendant with his or her post-arrest silence, regardless of whether the silence occurred before or after the defendant was given Miranda warnings. In its opposition papers, the OSP argues that the defense did not object to this line of questioning. However, the OSP's improper burden shifting constitutes plain error affecting Mr. Smollett's substantial rights, for which a lack of an objection is not fatal. Similarly, during the direct examination of Abimbola Asundario, Dan Webb asked him whether Mr. Smollett ever made a statement to the public where he admitted that the hate crime was a hoax. The defense did object to this question, and the court sustained the objection. Similar to Mr. Mendenhall's questions, which were not limited to the text message or even to the time period prior to Mr. Smollett's arrest, Mr. Webb's question is equally problematic. Now, the OSP argues in its opposition papers that the word statements to the public somehow makes Doyle inapplicable. This argument is frankly ridiculous, as any public statements by Mr. Smollett would have been used against him if he testified at trial, the same as if he had made those statements to police. Here, this entire case hinged on the credibility of Mr. Smollett and of the Asundario brothers. By improperly commenting on Mr. Smollett's failure to tell the police or the public that the Asundario brothers did nothing wrong, or to quote unquote come clean, the OSP violated Mr. Smollett's due process rights and his Fifth Amendment right to remain silent by improperly trying to shift the burden of proof to him. The OSP engaged in further burden shifting during its rebuttal argument, which is particularly prejudicial because it was the last time the jurors heard from any lawyer in this case. During rebuttal, Mr. Mendenhall stated, quote, "Mr. Uche gave you no evidence of any video that was missing." The court overruled the defense objection, which was error. In its opposition papers, the OSP tries to minimize this error by arguing that this was simply a single comment and that it was provoked because defense counsel had argued to the jury that there was a lot of missing data. But that's the prerogative of the defense to argue. Again, it's the state's burden. They put on a lot of surveillance video and they suggested to the jury that they had a complete account from the beginning of the night to the end of the night. And the jury had to be told that these were pieced together, but there was a lot of missing footage. It was proper for the defense to do that. However, it was not proper for the prosecution to put that burden on the defense and ask for the defense to produce the missing surveillance footage, which is simply, again, not our burden to do. And as the court well knows, a single comment is sufficient to constitute reversible error warranting a new trial. And we had cited in our papers the case of People v. Giangrande, and that's 101 Ill App 3rd 397. It's a 1981 case, and that's instructive. That also involved a single comment by the prosecutor in the closing remarks. And the remark was, "Where's the evidence?" And as the court explained in that case, the comment may well have improperly suggested to the jury that defendant had a burden to introduce evidence. Objection to it was overruled by the trial judge. This was error. And again, it was error in this case for them to make that comment and for Your Honor to overrule that objection. But we ask that a new trial be granted on that basis. And I'm going to turn lastly to the accomplice instruction. The court in this case committed reversible error when it refused to provide Illinois pattern jury instruction number 3.17 entitled Testimony of an Accomplice with regard to the Asundario brothers' testimony as requested by the defense. Pattern instruction 3.17 provides, quote, "When a witness says he was involved in the commission of a crime with the defendant, the testimony of that witness is subject to suspicion and should be considered by you with caution. It should be carefully examined in light of the other evidence in this case." Now, despite the title, the instruction is not warranted only where a witness is officially charged as an accomplice. Rather, Illinois courts have held that the defendant is entitled to have instruction 3.17 given to the jury if the witness, rather than the defendant, could have been the person responsible for the crime, or if the witness admits being present at the scene of the crime and could have been indicted either as a principal or under a theory of accountability, but denies involvement. Here, both of those circumstances are present, which require giving the accomplice witness jury instruction. The Osundario brothers were initially arrested because the CPD had not only probable cause, but substantial evidence that they were the perpetrators who attacked Mr. Smollett on January 29, 2019. And since then, in statements to the CPD and sworn statements to the grand jury in a trial, the Osundario brothers admitted to doing everything Mr. Smollett told CPD they did. Confront him on the street, yell racial and homophobic slurs at him, punch him, kick him, pour bleach on him, and put a rope around his neck. If it was not for their own self-serving statements and testimony that they did all of the above acts at Mr. Smollett's behest, they would have been charged with a hate crime, or at least a battery against Mr. Smollett. Because the Osundario brothers could have been the persons responsible for the attack on Mr. Smollett, pattern instruction 3.17 should have been given to the jury. Furthermore, assuming for the sake of argument that the Osundario brothers were in fact acting at the direction of Mr. Smollett as they alleged at trial, the only reason they were not charged as either co-conspirators or accomplices for their admitted participation in the attack on Mr. Smollett is because of their self-serving statements that they didn't know that Mr. Smollett would report the attack to the police. They asked the jury to believe that the elaborate staged attack was solely for the media's benefit, taking the absurd position that somehow a heinous crime against a high-profile celebrity, which was supposed to be caught on camera, would not result in a police investigation. Because the Osundario brothers admitted being present at the scene of the attack and could have been charged either as principals or under a theory of accountability, pattern instruction 3.17 should have been given to the jury. Now, the
charged with what?
Well, Your Honor, they could have been charged with filing a false conspiracy to file a false police report. They could have
There was evidence that they were part of filing the false police report?
Your Honor, there's so much law out there that you could file. There was certainly probable cause to charge them with being an accomplice to Mr. Smollett. Had they not participated, there would be you can't file a so-called false police report if there had been no attack. So clearly they were accomplices, clearly they were co-conspirators. Now, they weren't charged because they took the convenient position. We knew everything until the final step, which, was convenient. And obviously, in any other case, if there were other witnesses, I guarantee the brothers would have been charged. The only reason they weren't charged in this case was because the police needed them to prosecute Mr. Smollett. Without them, there was no case against Mr. Smollett, because as the court saw, there is not a single piece of independent evidence that shows that Mr. Smollett perpetrated a hoax, planned a hoax, or anything else. The only connection, and keep in mind, they subpoenaed, or they got a search warrant for 1 entire year of Mr. Smollett's cell phone data, location, text, voicemails, all sorts of communications. They couldn't find one thing that supported the fact that Mr. Smollett planned this. All they had was the brothers saying, after they got caught, after they were in custody for 47 hours, after they had been consulting with an attorney who was speaking to both of them, after that attorney showed them his Good Morning America video while they were in custody and they heard every single thing Mr. Smollett was saying, they conveniently turned around and said, oh yeah, you're right, we did do this, but it's because Mr. Smollett asked us to. And it was their own attorney who said she didn't say she gave a radio interview. She didn't say they came clean. She said, I pieced together what happened. I looked at the timeline. I looked at the CPD's evidence, and I put together a timeline of what happened in this case. And it's our belief that that story was spoon-fed to the brothers, and that that's the story that they gave police, which allowed them to be released from custody, uncharged. They became the star witnesses, and they've tried to capitalize on this whole regrettable incident. So we had cited the court to People v. Carrion, and that's 162 Ill App 3rd, 990, 1987. And that's one of the cases we cited in which the trial court's refusal to give such an instruction constituted prejudicial error requiring a new trial. Now, in their papers, the OSP doesn't address or attempt to distinguish this case because there really is no distinguishing factor, and that case is instructive. In that case, the court held that the trial court erred by refusing to give a cautionary accomplice witness instruction with regard to Amaya's testimony for the following reasons. and I quote, Amaya disclosed that he was with the defendant before, during, and after the shootings, notwithstanding his profession of innocence based on his alleged fear of the defendant. We believe probable cause existed to indict Amaya for the offenses, particularly when one considers that when he was initially taken into custody for questioning, he possessed money linking him to the crime. And in that case, the appellate court held that it couldn't find that the failure to give the requested instruction constituted harmless error, especially in light of the fact that Amaya's testimony was the only direct evidence implicating Carrion. And it's the same reason why giving this instruction was critical in this case, where the evidence against Mr. Smollett was far from overwhelming. I know the police department put on a long narrative, a lot of surveillance footage, but all that evidence was consistent with Mr. Smollett's testimony of his actions. He never denied seeing the brothers on the occasions where they went to great lengths to show, oh, on the 25th, he drove to the brothers' apartment. He admitted that. On the 27th, he met with the brothers. These are not things that were disputed. So that's not overwhelming evidence of his guilt. There were different interpretations of what that evidence actually meant. And the only direct evidence implicating Mr. Smollett was what the Osundario brothers said. And it was reversible error not to instruct the jury that they had a motive to lie about that testimony. It was that story that allowed them to avoid charges in a case where a convicted felon engaged in an attack on Mr. Smollett. He and his brother, if you believe the testimony, agreed to do this despite Ola's prior criminal felony conviction for a very similar attack on another individual, another group attack. But for all of that, it was really their own testimony that's the only direct evidence implicating Mr. Smollett. So under the circumstances of this case, the court should have instructed them that their testimony should have been cautiously scrutinized by the jury. And the court's refusal to provide this instruction under the circumstances of this case was not harmless and constitutes reversible error. In conclusion, I'd just like to say that although we believe each of the 13 errors outlined in our papers independently constitute reversible error and that each warrants the granting of a new trial, even if the court is not persuaded that any one of these errors warrants a new trial, we believe that the totality of trial errors undoubtedly affected the verdict, and the cumulative error certainly warrants a new trial. And there's ample authority supporting the grant of a new trial in such cases. And I'll just cite the court to People v. Lettrich, and that's 413 Ill 172. It's a 1952 case where the Illinois Supreme Court reversed the defendant's murder conviction and death sentence. In that case, there were a number of evidentiary errors alleged, including that the court erred in limiting and restricting the defendant's cross-examination of a critical witness, as well as certain inflammatory and prejudicial remarks to the jury in the arguments by the state's attorneys. In reversing the conviction and sentence, the Illinois Supreme Court stated that the totality of these errors compel us to the conclusion that this defendant has not had the fair and impartial trial, which is the inherent right of every person accused of a crime. And that's the same exact situation we have here. There have been a series of legal errors. If the court is not convinced that any one of them warrants a new trial, we'd ask that the court consider the totality and grant Mr. Smollett a new trial.
Thank you, counsel. Government wish to make a response to the post-trial motion of the defense?
We do, Your Honor.
Mr. Weaver, you may address the court.
May it please the court.
Counsel.
Your Honor, due to the sheer volume of the arguments here, about an hour here, and you've already mentioned the 83 pages that they've submitted. My partner and fellow Deputy Special Prosecutor Sam Mendenhall have bifurcated the opposition. I'll give an overview, and based on Ms. Gladian's presentation, I'll highlight 4 alleged errors. I believe Mr. Mendenhall will have a couple. To begin, I'll just start with a blanket statement that for everything prior to November 29, 2021, going backwards to 2019, for the alleged errors that they've incorporated by reference in their papers and the preamble to Ms. Gladian's presentation, we universally disagree that there was any error in those prior rulings. And we too, in our opposition and here today, will incorporate by reference our prior responses, briefs, colloquies with the court, arguments presented over the last couple of years on all those issues. And I will not retread them, but the record is clear for the issues that have been presented to Judge Tuman, for which we've been involved, for the issues that have been presented to this court, for which we have been involved, and for the issues that have been presented to the Illinois Supreme Court, for which we've been involved, are all incorporated by reference. At each stage, no matter the court or the judge that have heard it, each one of those prior rulings were proper, required by the law, and none need be nor should be revisited. And since Ms. Gladian brought it up, it probably is a good reminder that my firm of Winston & Strawn and the partnership did take this case pro bono. And our firm did, and Mr. Webb in particular, did shoulder that burden that was called for by the appointment of the special prosecutor. And we did so the entirety of the attorney time free of charge, not a dime. Limited expenses in the normal court. Judge Tuman's order did allow, and these are things such as court reporter fees, transcript fees, copying fees, those same fees that would exist for the Cook County State's Attorney's Office are expenses for which have been submitted to the county for reimbursement. They are minor compared to the amount of free service that our firm of Winston & Strawn has given to this county citizens and to the judicial system. Mr. Webb's appointment in particular as a special prosecutor was stemmed from Judge Tuman's 2019 June order in order to restore the public's confidence into the integrity of the criminal justice system, was answered by our firm, was answered by Mr. Webb, and you might just recall the 2 directives that required. The first directive to determine whether Mr. Smollett should be further prosecuted. That's what we're here for today. But it shouldn't be forgotten, and I don't believe is, but it's worth remembering that the second directive, whether any person or office involved in the initial Mr. Smollett case engaged in any wrongdoing, our office also did that. And you heard Ms. Gladian talk about certain of those things in our argument, but the OSP did complete a thorough investigation, did have a grand jury seated, did prepare a detailed and comprehensive report as it relates into the Cook County State's Attorney's Office, as it relates to the investigation in the Chicago Police Department, and did so for a total cost of attorney times for $0.00. And it should be noted, since it was raised, and it's important to understand that we believe we have fulfilled the call to restore the public's confidence into the integrity of the criminal justice system. As to the actual substance of Ms. Gladian's presentation, and as it relates to the 13, what I'll call macro level alleged errors, although they list a myriad of alleged sub-errors as well. The evidence presented at trial, Your Honor, overwhelmingly established Mr. Smollett's guilt beyond a reasonable doubt. And that's reflected in the jurors' unanimous guilty verdict. And nevertheless, Mr. Smollett asked this court for extraordinary relief to overturn the jury's verdict that found him guilty of 5 serious felonies of making false police reports. And in doing so, he raises a variety of alleged procedural, alleged evidentiary errors, both pre-trial and during the trial itself. committed by anyone and everyone involved in this case, except, of course, Mr. Smollett himself or his lawyers. And just a few examples. He's blamed the prosecutors. He's blamed Your Honor specifically. He's blamed the courtroom staff. These are in his papers. He's blamed the Cook County sheriffs in this courtroom. He's blamed the entire Cook County judicial system. He's blamed the Illinois Supreme Court. He's blamed COVID-19. He's blamed the media. He's blamed, quote, political figures. He's blamed witnesses at trial. And he's even blamed the jury itself, page after page after page of finger pointing and scapegoating. But once that bluster and hyperbole, Your Honor, is excised from that motion and the examination of the real underlying record is undertaken, it clearly reveals that each of the alleged errors is one, meritless, two, it is riddled with distortions of the actual record, and three, frequent misapplication of controlling Illinois law. But most importantly, none of those alleged supposed errors remotely will rise to the level of one, requiring overturning the jurors' unanimous verdict, nor two, the issuance of a new trial. As it relates to the alleged errors where Mr. Smollett seeks a judgment notwithstanding the verdict, here's what you didn't hear. You did not hear what the law actually says and what you'll have to weigh today. So I'm going to give it to you. Illinois law mandates that a judgment of acquittal is only appropriate when, quote, a trial court concludes, after viewing all the evidence in the light most favorable to the state, that no reasonable juror could find that the state had not met its burden of proving the defendant guilty beyond a reasonable doubt. And, quote, a motion for judgment notwithstanding the verdict should be granted in instances only where the state's evidence, when viewed in the light most favorable to the state, is insufficient to support a finding or verdict of guilty. Here, Mr. Smollett has not met and cannot meet the incredibly high standard for overturning the jury's verdict. And when viewed in the light most favorable to the state, that's the OSP in this instance, the evidence presented during the almost 2-week trial overwhelmingly, beyond a reasonable doubt, demonstrated that Mr. Smollett devised, orchestrated, carried out a fake hate crime, and then, in violation of Illinois law, repeatedly reported that fake hate crime to the Chicago Police Department as a real hate crime. And the plethora of evidence, just heard Ms. Glanian say, not a lot of evidence, or certainly not a lot of independent evidence. Here's a summary. The testimony of 5 Chicago police detectives and officers. The jurors heard the testimony of the Osendero brothers. The jurors heard cross-examination by the defense of each of those witnesses. The jurors received into evidence over 40 exhibits, including phone records, text messages, social media evidence, video surveillance, GPS evidence, receipts, and a $3,500 check written by Mr. Smollett to the younger Osendero brother. They heard the testimony of the defendant's 6 witnesses, and they heard Mr. Smollett himself. Hours and hours and hours worth of the defendant's own testimony. All that evidence, when viewed in the light most favorable to the OSP, it simply cannot be said with a straight face that no reasonable juror could find that the OSP did not meet its burden in proving Mr. Smollett guilty beyond a reasonable doubt. That's for the JNOV portion. As it relates to the remaining alleged errors that do not go to the sufficiency of the evidence at trial, that's when they say that those are more appropriate, perhaps, for a motion for a new trial. Illinois law tells us that a post-trial motion for a new trial is a matter for the trial court's discretion. Because none of the alleged trial errors you've heard or seen in their papers have any merit, this court should exercise its discretion and deny Mr. Smollett's alternative relief for a new trial. As it relates to the 4 errors I alluded to, Your Honor, that I just want to give a counter narrative to, since they were raised. 3 were raised. That's on the voir dire issue, the Batson issue, the accomplice instruction, and then I think it's also important to briefly touch upon one written about but not discussed here, which is the concept of the violation of his public trial rights. I'll just go in the order. Alleged error as it relates to voir dire. The court's voir dire process was plainly consistent with Illinois law and consistent with Rule 431. Notably, defense counsel didn't raise any objection at trial as it relates to the actual conduction. The rules language, as the court deems appropriate in Rule 431, makes clear that the decision as to whether to allow direct questioning is entirely within this court's discretion. Per Rule 431, the court conducted voir dire by directly questioning the prospective jurors, but consistent with Rule 431, the court exercised its discretion and allowed the parties to submit voluminous questions to be asked during the voir dire. Both sides, both the OSP and the defense, submitted rather voluminous supplemental questions for further inquiry of prospective jurors. Pre-trial, we reviewed those very thoroughly. We had colloquies on them, we had hearings on them, we had exchanges on them. Defense counsel ultimately submitted nearly 60 supplemental questions to ask during voir dire. The court took input, and importantly took input from the parties throughout the voir dire process, both at sidebar, in chambers, pre-trial, and during trial. And those additional follow-ups were often asked to the prospective jurors, and when they were not, the court explained why, in Your Honor's discretion, they would not be asked. No prejudice exists. Defense counsel was permitted to question the prospective jurors through the extensive supplemental questions, through the extensive supplemental questions that they submitted pre-trial, and through the supplemental requests that occurred during trial. Alleged error number 2, the Batson challenges. And I'll begin by noting unequivocally, the accusation that the OSP engaged in, quote, a systematic pattern of discriminatory challenges, end quote, is absolutely meritless. Lobbing unfounded accusations of jury discrimination that are belied by the actual record is unfortunately completely consistent with Mr. Smollett's attempts to interject and weaponize race and sexual orientation into these proceedings more generally. Just as he did when reporting the fake hate crimes of the Chicago police in 2019, just as he did when he took to the airwaves in 2019 in what is now perhaps the now infamous Good Morning America interview. The court heard defense motions made under Batson versus Kentucky as to the OSP's use of his peremptory strikes. Those occurred in chambers on the record. And when such motions were made, as Your Honor knows, under the Batson case, but also under Illinois law and People versus Davis, the defendant must first make a prima facie showing that the prosecutor has exercised peremptory challenges on the basis of race. And the court correctly concluded at the time, analyzed those motions under the standard articulated both in Batson and Davis, and found that the defense had not made a prima facie case of discrimination on the basis of race or sexual orientation. But even though it wasn't required to, the OSP, because of the challenges, even though a prima facie case had not been shown, the OSP did provide neutral explanations, both for race and sex, as to each of the preemptive challenges at issue. But rather than grapple with that actual record, which they didn't, you didn't hear it today, they didn't grapple with the actual record, and they didn't do it in their papers either. Because if you looked at the record and you saw things and the explanations as it relates to the challenges, undisclosed, disorderly conduct incident, a victim of a hate crime, avid watchers of Empire, getting news from TMZ, watching movies that starred Mr. Smollett, Googling the case, getting news only from social media or from Instagram, struggling to understand or hear questions. If they actually grappled with the actual record, it wouldn't fit the narrative that they wanted out in the media. Unequivocally, meritless motions that were offered the court's prior rulings all should stand on that point. As it relates to the alleged error number 3, the accomplice instruction on the IPI, the Illinois pattern instructions. As Your Honor knows, the court has discretion to determine which jury instruction should be given. Defense counsel sought, and you heard it here today, to include 3.17, that's the testimony of an accomplice, in the jury instructions. They've done it again here today to try to define the fake attack on Mr. Smollett, which is not a crime, as the crime for which the IPI 3.17, how they would like it to have been analyzed in the application of that instruction. But IPI 3.17 on its face has no application to this case. The Osendaro brothers did not admit, nor was there any evidence, that they were involved in the commission of a crime with the defendant. That's the language from 3.17. What is that? It would be filing the false police reports. And Mr. Smollett, not the Osendaro brothers, made the decision to file multiple police reports, false police reports, claiming he was the victim of an alleged hate crime. The Osendaro brothers could not have been the person responsible for the crime. That's what's required to get a 3.17 instruction, because they did not assist nor participate with Mr. Smollett in the filing of the false police reports. Moreover, Your Honor, the Osendaro brothers did not admit to participating or otherwise being present to the reporting of the fake hate crime to police. Therefore, they could not have been indicted for disorderly conduct or for filing a false police report. The court properly and correctly exercised its discretion in not giving the 3.17 instruction, and that ruling should stand. Lastly, Your Honor, a significant amount of ink was put into the last topic I'm going to discuss, which is the right to a public trial. As everyone in this room knows, this trial took place in the middle of a global pandemic, right on the cusp of the Omicron variant. This court did a great job holding a public trial. All necessary parties, the court, courtroom staff, Cook County sheriffs, the OSP, defense counsel, the jury, media, numerous members of Mr. Smollett's family, numerous of his friends, members of the public at large, were able to attend every single day of the trial proceedings. The logistical efforts for which the defense has taken swipes at this court and this courthouse deserve to be commended, not bashed. The defense objected to having cameras in this courtroom during the actual trial, and they objected to having cameras in this courtroom at every step of the way. And the court respected that objection in declining extended media coverage up until today's hearing. Having the cameras in the courtroom, which they objected to, would have allowed an unlimited number of people to view the trial. Their papers struggle with this. They acknowledge the position. I'll coin it sort of their Goldilocks position. Your Honor, don't make the trial too public. And then once you did that, today it's not public enough. And they've alleged that no members of the press were in the courtroom during any of the jury selection process. Not so. The court knows there were at least two members of the media that were present in the courtroom, probably both of whom are here today, that sat in the corners during the process of voir dire. Many more were sitting at the courtroom exits and standing. These doors were open. Those doors were open. The doors to the Your Honor's courtroom across the hallway were open. Chairs were provided. And while the sheriffs did a great job trying to get people in the seats, there were a lot more people that weren't in seats. And for anyone that actually sat in here, which they did, I did, they did, knows there's a lot of people peeking in and out during the voir dire process. The concept that Your Honor closed the courtroom just belies reality. Your Honor kept the courtroom open. Members of the press were here. They were able to keep account of what was occurring. In fact, were accounting as to what was occurring. It doesn't remotely come close to any violation. The Radford case, which we cite, demonstrates that the court's use of the entire courtroom for the veneer, but not for the remaining portion, doesn't call into the question the confidence of the public integrity or impartiality of the court system. Mr. Smollett knows he had family present. They sat right there. They had strategy huddles. They passed numerous notes to his lawyers. They held prayer sessions. You allowed his entire defense team, his PR team, his friends. You never took a head count on them. You were gracious in understanding that the defendant's right to a fair trial had to be weighed against a global pandemic, and it was commendable. You did not err, and you certainly did not violate Mr. Smollett's Sixth Amendment right, and he certainly doesn't deserve a new trial. Generally, but certainly for that specifically. With that, Your Honor, if you have any questions, I'd like to turn it over to Mr. Mendenhall.
Mr. Mendenhall?
Your Honor, Ms. Blandin is entitled to her own argument. What she is not entitled to is her own facts. She stood before this court and told you they raised the issue of David Elderby's direct examination. Nowhere in this 83-page motion did they ever make a single complaint about the examination of David Elderby. Ms. Blandin stood before this court and told you that they made a motion to recuse the whole Office of Special Prosecutor, Mr. Webb, myself, Mr. Weaver. Nowhere at trial or in this paper is there such a motion. Your Honor, as we established at trial, facts matter, truth matters, evidence matters. They are not entitled to their own facts. Another fact in this matter, Your Honor, the one disqualification that they did make was to recuse the deputy special prosecutor who examined Mr. Moore. That deputy special prosecutor is an honorable man, is a man I worked with for 20 years. His integrity is impeccable, his reputation is impeccable, and his ethics is impeccable. Your Honor, they say he put Mr. Moore on the stand to commit perjury. Mr. Moore got on the stand and testified that the person he saw was white. Your Honor is well aware, the actual two people that ran by him got on the stand and testified. Abel Osendero, Evan Ola Osendero. Your Honor, if nothing else has been established in this entire trial, I think we can both agree it's been established that they're not white. Yet they came in here today and making that same argument. Their arguments is in wine. They're not getting better with age. Your Honor, to try to discredit a man and to call into question when all he did is serve pro bono faithfully and for free does a disservice to the job that this Office of the Special Prosecutor did. And not only did they not prove anything that merited disqualification, they did it with pure gamesmanship, Your Honor. The rules require that you bring it to the court's attention in advance. They waited till the witness got on the stand and had him point at the deputy special prosecutor. Your Honor, and these are your words exactly, Your Honor, you said this was the first time in your history of a judge where you ever seen a witness get on the stand and point at a prosecutor. I've never seen it. I suspect no one in here has ever seen that. Your Honor, the gamesmanship cannot be rewarded. Their alleged error that the deputy prosecutor should be disqualified should be summarily denied as meritless. Second point of error, Ms. Landian raised. She said that the Office of the Special Prosecutor commented on Mr. Smollett's post-arrest silence and post-Miranda silence. We did no such thing. On February 14, 2019, in an unsolicited, voluntary, non-custodial interview with the Chicago Police Department, Mr. Osendero sends Abimbola Osendero a text saying, "Brother, I love you. I know 1000% you did nothing wrong and never would. Neither you nor your brother. I love you. I stand with you. And I'm going to make a statement making sure everybody knows you did nothing wrong." It was voluntary. It was non-custodial. How do we know it was non-custodial, Your Honor? Mr. Smollett got up and left after the interview. He wasn't taken into custody and was represented by one of the finest lawyers in Chicago. To say that when we questioned Detective Deese about that text, that we put in play Mr. Smollett's post-arrest silence when all of our questions simply asked him about a pre-arrest, pre-Miranda text that he sent when he was free to go and did in fact leave, is wholly without merit, Your Honor. To then say that when Mr. Webb questioned Abimbola Osendero about the same text that he received from Mr. Smollett on February 14th, way before Mr. Smollett was ever arrested, way before he was even Mirandized, is equally without merit, Your Honor. The text stands for itself. Their problem isn't with the question. Their problem is with the text that their client sent. Because it said a lot. I know you did nothing wrong. I know you never would. I know 1000% you didn't. I love you and I stand with you, and I'm going to make it right. We had every right to ask if that was ever made right. And lastly, Your Honor, they raised an error that we allegedly shifted the burden during trial. They alleged 3 separate times. Once again, Your Honor, facts matter, truth matter, evidence matter. In their 83-page brief, they raised one issue concerning that, and that was at closing. When Mr. Uche stood right there in his very well, looked at the jury and told them, "Ladies and gentlemen, there was a ton of videos missing. There was a ton of evidence missing." The case law is clear on that, Your Honor, that when the defense opens the door in closing argument and raises an issue, the prosecution or the state has an absolute right to respond. They opened the door and now they're complaining that we walked in. We walked through it. Your Honor, we simply responded to his claim that there was missing evidence. Detective Deese took that stand and made it abundantly clear. Not a single piece of video was missing. Every video that we had was turned over and that they had it. No video was missing, Your Honor. And for them to raise that argument, we were entitled to respond, Your Honor. So my role was to address the trial errors. I wanted to do it in a summary fashion because we've been going a while now. But those 3 errors that Ms. Landian raised are simply not supported by the record. She's entitled to her own argument. She's not entitled to her own facts. We thank you for your time. We respectfully ask that you deny the motion, and the state is ready to proceed to sentencing.
Anything else you want to add?
Very briefly, Your Honor. Your Honor, Mr. Mendenhall began talking about the second prong of the of their appointment by Judge Tuman, which was to see if there was any wrongdoing in the dismissal of the charges against Mr. Smollett in the initial indictment. Now, I know there was some public outcry after the sudden dismissal of the charges. However, the OSP did a thorough investigation. And the one thing they did not find was any misconduct on the part of Mr. Smollett, anybody surrounding him or his team, in the dismissal of the charges against him. And that's critical because that impacts the fact that the agreement should have been honored. Now, whatever may or may not have gone on at the state's attorney's office, whatever the inner workings are, has nothing to do with the expectation that Mr. Smollett had when he entered into an agreement. He performed his part. The state's attorney's office at the time performed their part. The court enforced that agreement. And again, we know from the OSP's investigation that there was absolutely no wrongdoing on the part of the defense in bringing about the dismissal of charges against him. That was something that was offered in the discretion of the state's attorney's office, and he was entitled to rely upon it, which he did to his detriment. As far as the voir dire questions, I just want to emphasize that we're not talking about every single question. I know Your Honor asked a few questions or raised a few examples saying that those are not things that needed to be asked. For the record, I just want to identify the 4 questions that we thought were significant to determine if any of the potential jurors had any prejudices or bias that would deprive Mr. Smollett a fair trial, and the 4 questions that we had asked the court to inquire of the potential jurors and that we believed based on this court's order stating that the court would address these topics were: number 1, are you or is anyone close to you a member of the mainstream media? 2, do you have any particular feelings one way or another about actors? And this was critical because Mr. Smollett as an actor testified. 3, would the sexual orientation of Mr. Smollett or any witness have any bearing on your ability to reach a fair decision in this case? And 4, do you believe that you would give more or less weight to the testimony of a law enforcement officer as opposed to the average citizen? And these were important questions. Again, in light of
Are you sure those questions weren't asked, albeit in my words, not your words? Are you sure about that?
Yes, Your Honor. We've reviewed the record. We put this in our motions. Again,
I think you might be mistaken.
our review of the record tells us otherwise. Now, as far as the accomplice instruction, Mr. Weaver said that the Osundario brothers could not have been charged with filing a false report because they weren't present when Mr. Smollett reported the attack to police. That is completely absurd. It's like saying somebody can't be charged as an accomplice to murder or a co-conspirator in a murder if they're not physically standing there when someone shoots the gun. It's a silly argument. The Osundario brothers absolutely could have been charged as an accomplice or a co-conspirator. There was probable cause. Despite their denial, they could have been charged. People in courtrooms all across the country are charged every single day with less evidence for conspiracy-based crimes or as an accomplice. They absolutely could have been charged in this case. The CPD and the state's attorney's office made a decision not to charge them because they wanted their testimony against Mr. Smollett, but that doesn't mean they couldn't have been charged, and it doesn't mean that the instruction should not have been given because they do satisfy the requirements necessary requiring that instruction to be. And Mr. Mendenhall stated, I'm not entitled to my own facts. I'm certainly not here creating any facts. The record speaks for itself. Anthony Moore took the stand. He stated what he stated. We have the transcripts to show that. And he's the one who got up on the stand and said he was threatened and pressured. And when I made reference to disqualification, I certainly wasn't suggesting that we asked for the entire OSP to be disqualified. I was up here, I'm not trying to name any individuals. Our papers are clear as to our disqualification motion. I believe Your Honor already knows that. And finally, just to address the post-arrest silence issue, Mr. Mendenhall wants to isolate the statements as relating to the text message. And he says that these were all statements, or he was referring to the fact that that text message exchange on February 14th was prior to the fact that Mr. Smollett was arrested. However, that's not the question that was asked, and that's not what the jury heard. The questions said, to this day, has Mr. Smollett ever come clean? Has he ever said that the Austin Dario brother, it basically says, has he ever corrected the record? And it was specifically, the language was to this day and has he ever. And so that necessarily includes post Miranda, as he was sitting in trial as a criminal defendant. And so we think all of those things were error. And as far as the burden shifting, Mr. Mendenhall says there was no missing video. There in fact was. There was no video footage of one of the taxi rides, which made no sense because it had been, the CPD had apparently obtained that video. However, it was nowhere in the discovery. Later, we were told it doesn't exist, but there was missing video, not to mention all of the pieces of surveillance footage that obviously they weren't able to obtain. So again, it was fair game for the defense to comment on those things as the prosecutor's failure to meet their burden and to have the jury wonder about those things. It was not fair game for the prosecutor to do what they did, which is shift the burden and put it on Mr. Smollett to have to prove his innocence and have to come up with this evidence that he simply didn't have. So again, as we asked the court to grant a new trial in light of the totality of errors that have occurred and have deprived Mr. Smollett of a fair trial. Thank you.
Everybody done?
Nothing further.
Okay. All right, let me indicate that we've been talking about these very issues for the last couple of years. Most of them are pre-trial, and certainly there's some that took place at trial. I've never had a case that has been pled as exhaustively as this one. Voluminous writings, hundreds and hundreds of pages of filings, asking for multiple motions to dismiss, jeopardy claims, motions to disqualify counsels, all of which are contained in the post-trial motion. It's fair to contain in the post-trial motion, but I mention now that these have been vetted and records have been made, and I've articulated myself at great length on all these issues in the past. And I am comfortable with the colloquies that were had and the decisions I made as a result of those colloquies. Just a few matters right now I want to address, and I think I should because they've been brought up with some passion by Ms. Glandian. There has been some suggestion that somehow this court should not have allowed the second indictment to go forward because it was invalid, because somehow Judge Leroy Martin, chief of the criminal division at that time, when he appointed Michael Tooman, or asked Michael Tooman to be the one to preside over Sheila O'Brien's petition seeking a special prosecutor, that somehow that was flawed, that Judge Tooman, when he held hearings, and he held exhaustive hearings, and his report speaks for itself, that somehow those proceedings were flawed, and a special prosecutor never should have been appointed, and that I somehow should have been in a position to grant some kind of collateral relief and dismiss the second indictment because the appointment of special prosecutor in the first place was invalid. I've read all of those transcripts, everything that took place in all of the hearings before Judge Martin and then Judge Tooman. Judge Tooman issued his report. He took it under advisement and believing there were lengthy hearings that were held on this matter. He found that the appointment of a special prosecutor was necessary. Now, that doesn't mean that he's assuming that Mr. Smollett's guilty of something. It didn't mean that he assumed that the Cook County State's Attorney's Office was guilty of some misconduct or had done something terribly untoward or unethical. All it meant was that under the totality of the circumstances, a second look was necessary, that public confidence in this entire affair was shaken and a second look was necessary. He appointed Winston Strawn, Dan Webb in particular. I find nothing wrong with Judge Tooman's reasoning, his analysis. I'm not sure I have the right to offer a collateral remedy, because I'm just a trial court judge on the same level as Judges Martin and Tooman. But be that as it may, I happen to agree with their reasoning that they found that the appointment of a special prosecutor was necessary, and all they did was investigate, and then they found things after that. A report was made about the Cook County State's Attorney's Office, and obviously a second indictment came as a result of their investigation about the circumstances of the case involving the conduct involving Mr. Smollett. All right, that's that. As to a public trial, we were in COVID. This was the first jury trial that this court held, and I am an active jury litigator and have been for years and years and years. This is the first trial I was able to have since COVID, and COVID was still happening. We were under all kinds of constraints. I was told that I could only have half capacity in the courtroom, including the jurors, including the deputies, including the lawyers. I had multiple lawyers on each side. I think the defense team is 6 lawyers. The prosecution with their staff is even more. I asked the parties, how many seats do you need in the courtroom? The defense came to me at first and they said, we need 42 seats in the courtroom. It's 42 out of 57, including the jurors. I had media requests. The defense told me specifically, I asked them, do you want cameras in the courtroom? Shall this be televised? The defense said, no, we would not like it televised. The prosecution said, we don't take any position. Whatever Your Honor decides is fine. But I deferred to the defense. I understood that this is a delicate matter and preferred not to have it on television. So I agree. There shall be no television. I did the best I could to have a public trial. We did things that we don't normally do. We kept the doors open. We had seats outside the doors that were open. We had seats set aside for the media because I knew that the media would be making this as public as possible. We did have people coming to the courtroom, and ultimately, and there was no limit on the amount of people that were here as family and supporters of Mr. Smollett. So I am confident that I did all I could to give a public trial that the Constitution requires. We were under severe limitations based on the COVID virus. Last thing I want to talk about is the accomplice instruction. There's been a lot of talk about this, and I did take this seriously at the time when it was brought up. We have to remember why we were here. Mr. Smollett was indicted for filing a false police report, felony disorderly conduct. Everything about what happened between he and the brothers, the plan that the jury found happened, the scheme to meet on the street and pretend to beat him up and call him names and do the things that they did, none of that's a crime. There was, because Mr. Smollett was consenting to it, not only consenting to it, he had orchestrated it, according to the evidence. There's nothing you could find the brothers guilty of. They didn't commit any crime. The only crime that was at play in this entire scenario was the false police report. When the police were called, the brothers were no longer there. They weren't consulted. They were out of the picture. The problem that Mr. Smollett has are what he said to the police and what the jury found that he said to the police, and that it was patently false. That was the problem. And the brothers had nothing to do with that. And because the crime at issue was the filing of the false police report, the felony disorderly conduct counts, I found that the brothers had nothing to do with that portion of it, and the accomplice instruction for those reasons would not lie. And so I just want to put that to rest. And we talked about that at length previously, and I know Ms. Landian is serious about it. That's fine, but I see no problem with that. As to the rest of it, we've talked about this for 2 years, and I have made records both orally and in writing on each of these issues, even some things that were not raised orally today. I'm going to stand by my findings and rulings. I do believe at the end of the day that Mr. Smollett received a fair trial, that he was proven guilty beyond a reasonable doubt by the jury based on the evidence that was presented, that there was nothing unconstitutional about these proceedings. His motion for post-trial relief was respectfully denied. We're going to go further. I'm suggesting we take a short recess, and then we're going on to the sentencing hearing. Let's take 10 minutes.
We've been listening in here to the motion, the request for a new trial, and we've heard it. Boy, we've been going back and forth here, both sides, for upwards of almost 2 hours now. They convened court just a little bit after 1:30, and here we are at 3:10. So that gives you an idea of how long it's taken just for this first half of what we're considering in the sentencing hearing for Jussiesmollett. And they are taking a short recess, so that's why we are back on the seal here at the courthouse at the Layton Criminal Court Building, and we will wait to see how long they will continue to be in recess before they move on to the next stage. So, you know, at this point, we are still waiting to hear from many of the witnesses that Jussiesmollett and his team will put forward, including his 92-year-old grandmother, who will be speaking on his behalf. We're also hearing that his older brother will be speaking as well. He was accompanied by many of them as he walked into the courtroom. And from what I'm understanding from Irv Miller, we'll bring him in shortly, many of these letters that we have been getting in preparation for the sentencing hearing, those will be quoted from, a lot of them coming from Jesse Jackson locally and the NAACP. So I want to bring in Irv Miller now. Irv, you've been listening to a lot of this, I'm sure, and it's extensive. Even at times, the judge stepping in to question many times Jussiesmollett's attorney on some of the points that she was making here. So what stood out to you?
What stood out to me was what the judge thought was important, because he didn't comment upon everything that either side brought up to him, but he did spend a lot of time talking about what happened before Judge Tooman in appointing the special prosecutor's office to begin with, because he knows that that is a ripe issue for appeal. And he did say he agreed with Judge Tooman's ruling, but also said he was not going to act as the appellate court over Judge Tooman, since they are of equal level in the court system. And I have to agree that it is a ripe issue, and I think that it will be addressed in the appellate court. I think he was right when he said that every other ruling that he made was correct, and that the items in the post-trial motion issued by Mr. Smollett, he didn't find any merit with any of them. But yet again, this will go to the appellate court. I assume Mr. Smollett wishes to appeal, but that will be an issue that he may have a shot at.
Irv, now we are still waiting to get to the heart of what a lot of people are waiting for, because I know you've been very skeptical all along that this motion for a new trial would at all be considered. So as we look to the sentencing phase, the fact that we've been listening in and the judge has been patiently considering all of this, what do you expect to be the next steps for the sentencing phase?
Well, I think you're going to hear live witnesses. I think you may hear argument by the defense attorneys about what are in the letters. I think you may hear the judge even comment upon what he's read in the letters and what he's going to consider in making his decision as to what the appropriate sentence is. He's got to take everything into account. He's got to take that pre-sentence investigation that was prepared by the probation department. It goes into all the factors about Mr. Smollett's life, education, work, drug use, everything. Take into account the letters, take into account any statement that Mr. Smollett may want to make in trying to come up with a decision. And as I said earlier, I don't think that Judge Lynn has made a decision yet as to what the sentence is going to be. He wants to hear what Mr. Smollett says. He wants to hear from his mitigation witnesses, family members. And again, I think he's going to take a serious account of what's in those letters, those mitigation letters that people took the time to write, and give a little insight into the life of Jussiesmollett.
So, Irv, you've known the judge here. I know you were talking about your relationship with him at various times, as you both have been in the court system here in Illinois over decades. And I thought it was interesting when he was cutting in, asking questions of Jussiesmollett's counsel. They seemed to be thoughtful. He wasn't really, getting an attitude by any means with her, but he definitely had pointed questions when she was talking about, for instance, whether he should have allowed all of the questions that she wanted at different parts in the procedure. So what's your take on that in terms of his ability to navigate attorneys who have extensive briefs and are willing to bring forth lengthy arguments at many times?
Well, you could tell by this hearing that when it comes to Judge Lynn making a ruling, he's short, sweet, and to the point. He knows what he's doing. He knows the law, and he'll put his 2 cents worth when he thinks it's important and keep quiet when he doesn't think it's important. That's why he didn't address every issue that the defense brought forth today, but he was critical of some of the things that were said, particularly like the accountability instruction. He said to the defense attorney, "What crime are you referring to when you think that the brothers are accountable? They weren't part of this crime that Mr. Smollett is charged with. This is disorderly conduct based upon filing a false police report. It has nothing to do with what happened on the street with the rope and the battery and the things that happened in the middle of the night. This was about filing a false police report. And who's the accomplice? There was only one person doing it, and that was Mr. Smollett.
Yeah.
So he let them know how he thought about that particular issue.
And for more on that, we want to go back to a little of that sound from the judge as he was questioning counsel there for Jussiesmollett. Let's listen.
There are certain questions the court asked, and this was my next point with Rosemary Mazzola, where the court cut off the answers.
I think I asked most of the questions the defense requested of me. There were some I did not. For example, you wanted me to ask the denier, what kind of animal would you like to be if you had to be an animal? Or Superman or Batman, what do you prefer? Did you really think I was supposed to ask a denier when I'm choosing a jury in a criminal case, those kind of questions?
We identified certain questions in our motion that we think, I believe there were 4 questions that we thought were critical, not the ones Your Honor just mentioned, but there were important.
That was part of the pool of questions I received from you.
Right, but there were important questions that were not asked. And the more significant factor is we should have been allowed to question the veneer in this case. Again, I'm not saying in every case. I respect that Your Honor doesn't do that in a lot of other cases. However, this case is obviously unique. Mr. Smollett, unfortunately for him, has not been treated like anyone else charged with class 4 felonies. He's been disadvantaged at every turn, and his jury selection.
I pick a jury in this case the same way I pick a jury in a murder case. I do the questions. I ask the lawyers for input. Tell me what questions you want me to ask. I vet them. And I'm happy to ask the questions that are relevant and helpful.
I understand, Your Honor.
But just the only point I'm trying to make is that I absolutely treated him the same as everybody else. And I didn't distinguish him from a class 4 offender or potential offender from a person accused of murder.
What kind of animal would you be? Boy, he handled that with a lot of patience there, Irv. Okay, one more question. I want to bring in my colleague, Brad, to continue this conversation. So just in terms of the players here, we, of course, have seen counsel for Jussiesmollett, and we know the special prosecutor. But there was another gentleman who spoke as well, and he was speaking directly to some of the points that Jussiesmollett's counsel made. Just take us through, so for those at home, they understand the key players here and how all this works together.
Well, right now you have the lead prosecutor, which is Dan Webb. He did not take part at all in this post-trial motion asking for a new trial. He let 2 of his assistants divvy up and basically each one do 50% of the argument. I guarantee you, I hate to guarantee things, but I guarantee you that he will take an active participation in this next phase that's coming up, the sentencing hearing, because the prosecutor's office always has a right to argue an aggravation. And I would be shocked if it's not Dan Webb who will be the participant doing that.
Thank you, Irv. And it's good to be back. Erica, of course, trying to jump in and out for just a little bit because we are getting newscasts together at 4, 5, and 6 coming up with the news of the day and this. So, Irv, I want to go back to you. It was interesting when the defense was talking to the judge in this case. Although they said, with due respect and with respect and with respect, but there was clearly some combat going on, and there was clearly some consternation between the 2 parties. And then really, Team Webb doubled down on that. At one point in time, the first lawyer went into the soliloquy thanking the court for its prudence in handling the matter, thanking the sheriff's department, how remarkable it was they were able to do this all with COVID-19 happening. I know you can't really nickel and dime someone, but does the defense questioning the judge so hard, then, won't that have an effect on how he sentences Smollett, or does he just block that out, have ESP say that that's one part, we go on to the next?
He's gonna put that aside. He's really a fair judge. You mentioned, actually, Erica mentioned a few minutes ago that I've known him for a long time. I was actually a supervisor in the state's attorney's office. He goes out of his way to be fair, and you could tell by the colloquy that you heard between him and the defense attorney that he was trying to keep his cool. There's an expression that judges try to say once in a while: think it, don't say it. And you could just see that he wanted to say more and was holding back because he wanted to keep the decorum of the courtroom just the way it should be.
Yeah. So, Irv, we want to go back to a recap of some of the sound that came from the prosecution when they were talking about this blame game that was going back and forth. So let's go to that.
The evidence presented at trial, Your Honor, overwhelmingly established Mr. Smollett's guilt beyond a reasonable doubt. And that's reflected in the jurors' unanimous guilty verdict. And nevertheless, Mr. Smollett asked this court for extraordinary relief to overturn the jury's verdict that found him guilty of 5 serious felonies of making false police reports. And in doing so, he raises a variety of alleged procedural, alleged evidentiary errors, both pre-trial and during the trial itself, committed by anyone and everyone involved in this case, except, of course, Mr. Smollett himself or his lawyers. And just a few examples. He's blamed the prosecutors. He's blamed Your Honor specifically. He's blamed your courtroom staff. These are in his papers. He's blamed the Cook County sheriffs in this courtroom. He's blamed the entire Cook County judicial system. He's blamed the Illinois Supreme Court. He's blamed COVID-19. He's blamed the media. He's blamed, quote, political figures. He's blamed witnesses at trial. And he's even blamed the jury itself. Page after page after page of finger pointing and scapegoating. But once that bluster and hyperbole, Your Honor, is excised from that motion and the examination of the real underlying record is undertaken, it clearly reveals that each of the alleged errors is 1, meritless, 2, it is riddled with distortions of the actual record, and 3, frequent misapplication of controlling Illinois law. But most important, none of those alleged supposed errors remotely will rise to the level of 1, requiring overturning the jurors' unanimous verdict, nor 2, the issuance of a new trial.
So, Irv, there were a lot of clearlies in there, and I know this is a point that you were making well before the hearing even got into session here. You think in terms of the new trial motion that it's really the chances, the likelihood of this are nil.
I would say that because the procedural objections that the defense has, and which are typical, you either blame the judge for making mistakes, the jury for making mistakes, or the prosecutor for making mistakes. That's the typical areas that you go after in a motion for new trial. But as I said earlier, there's one other procedural issue, and that's whether or not this case should have been brought at all, whether or not Judge Tooman had the right to appoint a special prosecutor. And I think that's a ripe area for appeal. I'm not saying it's going to win, but I'm saying that's an area I think that the appellate courts may spend some time on trying to determine if any of this should even have taken place. So that's my 2 cents worth as far as with where this may be going.
Yeah, that's an interesting point. So you're saying, should it have even have gotten to the point where you have a judge who is then assigning a special prosecutor? Should it, as the defense argued, should it have been tied up and shut down when he basically forfeited his $10,000 bond, correct?
Exactly. And, you know, when the defense talked about, hey, listen, we made a deal with the prosecutor, and the prosecutor had the right, Kim Fox, by the way, is the prosecutor, the defense has the right to rely on what a prosecutor says, and that shouldn't result in a new trial, I mean, a separate indictment, rather. I mean, last week we saw the United States Supreme Court deny the state of Pennsylvania's request to retry Bill Cosby because the prosecutor made a promise to him that they wouldn't use what he said against him. And that backfired on the prosecutor. So I'm not saying that that is totally on point, but I have to think you have to look at that as a little guidance. You know, when a prosecutor makes a promise, it's got to be kept. Whether or not this was considered a legal promise that has authority behind it, I think is a good question for the appellate court to decide.
Yeah, Irv, as you're talking here, we're starting to see live video back inside the courtroom. So, you know, as they adjourned, we went back up to the seal, and now we can see Jussiesmollett standing at his table with members of his group. And you can see just in terms of the perspective there, the judge sitting to the left and Jussiesmollett, as you circle, pan across that, you can see where the special prosecution sits. And then you can get a view of who is inside the courtroom. And, this is something that we don't often see. And we spoke about this before because there were requests, Irv, and you mentioned this previously, to do something unprecedented in a lot of these cases, which is actually to have the cameras in the courtroom. And that was at some point denied, and then it was allowed, Irv, is that right?
Well, it was denied for the trial because the judge was concerned that the jury would be tainted by what they would have seen by looking at television recaps at night, or people saying, hey, listen, I saw this on TV, here's my opinion about it. So we protected Mr. Smollett's rights at trial. But there's really no need, there's no objection really to have a sentencing hearing be televised. The judge isn't going to be biased, isn't going to be prejudiced or tainted by anything that the media could do that would interfere with a fair sentencing hearing.
Okay. And there was also an interesting series of questions brought up. It was a really interesting series of arguments, even in about one juror in particular. But let's kind of get out of the weeds for the minute. Let's get into the bullpen. That's where the reporters are. That's where the gaggle is. And amongst them is CBS 2 investigator Dana Kozlov, political investigator. Dana, the mood down there, see any movement, hear anything? As we do see a little bit more movement in the courtroom. We may cut you off to fit any time, but kind of give us the latest there.
Yeah, really, it's just a lot of wait and see down here. Charlie DeMar, my colleague, of course, up in the courtroom, getting a firsthand glimpse at the proceedings. But down here, it's quiet. No members of Jussiesmollett's entourage, if you will, came down that I could see during the break.
All right, Dana, as we said, we may need to
Sounds
cut
like
you
court's
off.
resuming.
It
And
does
we can hear
appear.
that. It sounds like the judge is speaking. Let's listen in.
Sorry.
Any corrections or amendments?
No corrections, Judge.
All right, then we'll proceed on further. I will inquire of the government, do you wish to present evidence in aggravation, either witnesses or documentary evidence?
The answer is yes, Your Honor.
Sure. You may do so.
Mr. Mendenhall will be presenting the witness statement.
Your Honor, I have a victim impact statement that I would like to, I've been asked to present on behalf of the City of Chicago and Superintendent Brown of the Chicago Police Department. As you correctly pointed out, as of